Hello, greetings. Welcome to Attaining the Second Cognition. This is Doug Michael. Once again, ladies and gentlemen, thank you for taking your time to join me and to open your mind and consider new ideas. It's greatly appreciated. Today, we're going to discuss a topic that is more geared towards an American audience in this presentation, for the information presented in this video is relevant to every American, and this information is designed to remove a major perceptual illusion believed by Americans in general. The topic of this discussion is, you have no constitutional rights. At first gloss, by making such a statement, most of my subscribers are liable to bristle up and say that we're full of it by making such a statement. But I ask the viewers' forbearance to listen to the irrefutable evidence provided in this video that will prove the foundation of this claim. Too many Americans falsely believe that the U.S. Constitution grants them some kind of rights, yet all it takes is a reading of the Declaration of Independence to see that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. With this one simple yet profound statement, it is inarguably apparent that these unalienable rights are not granted by the Constitution, but are in fact inherent rights due to all humans, although not officially proclaimed in other nations around the planet before this Declaration of Independence was composed. When we acknowledge these inherent and unalienable rights endowed by their Creator, it is an acknowledgement that no institution created by man has any authority to overshadow or handicap these rights. In the Fabian-controlled public school system, it is a rare case indeed where you find any courses in the Constitution being taught anymore. Before the Fabian takeover of the public school system, study of both the Declaration of Independence as well as the Constitution were mandatory in every school, so every individual was brought up with the knowledge of these documents in order to be educated in the principles of the law and also their civic responsibility in understanding their documents of government. This information is no longer taught in the public school systems. Many Americans have heard of the Federalist Papers, and this is only natural because they present the opinions of those who endorsed the Federalist form of government after the composition of the Constitution. What is less known is the Anti-Federalist Papers. Without knowing about the Anti-Federalist Papers, the Federalist Papers occur in a historical vacuum without the natural context of their presentation. We have to put things in focus here for our American viewers so they can better understand what took place with the composition of the U.S. Constitution. At the time of the Revolutionary War, the 13 original colonies were a loose confederation of political bodies, each with their own self-interests within their territorial boundaries, with some being slave states and others not. After the Revolution, these original 13 states, in struggling to come together in agreement on how to work together, created what is known as the Articles of Confederation, which were the forerunner of what ultimately turned into the Constitution. The Articles of Confederation were adopted by the Continental Congress on November 15, 1777, but were not officially ratified until March 1, 1781. In brief summary, even unratified, the Articles provided a system for the Continental Congress to direct the American Revolutionary War, conduct diplomacy with Europe, and deal with territorial issues and Native American relations. Nevertheless, the weakness of the government created by the Articles became a matter of concern for key nationalists. On March 4, 1789, the general government under the Articles was replaced with the federal government under the United States Constitution. The new Constitution provided for a much stronger federal government by establishing a chief executive, the president, courts, and taxing powers. In 1867, just after the ending of the Civil War, a man by the name of Lysander Spooner authored several essays. In one titled No Treason, the Constitution of No Authority, Spooner, a lawyer and philosopher, revealed the truth concerning the Constitution and whom it applied to as a contract. Spooner was right on the mark when he wrote, "The Constitution has no inherent authority or obligation. It has no authority or obligation at all, unless as a contract between man and man. And it does not so much as even purport to be a contract between persons now existing. It purports at most to be only a contract between persons living 80 years ago. And it can be supposed to have been a contract then only between persons who had already come to years of discretion, so as to be competent to make reasonable and obligatory contracts. Furthermore, we know historically that only a small portion, even of the people then existing, were consulted on the subject, or asked, or permitted to express either their consent or dissent in any formal manner. Those persons, if any, who did give their consent formally are all dead now. Most of them have been dead 40, 50, 60, or 70 years, and the Constitution, so far as it was their contract, died with them. They had no natural power or right to make it obligatory upon their children. It is not only plainly impossible, in the nature of things, that they could bind their posterity, but they did not even attempt to bind them. That is to say, the instrument does not purport to be an agreement between anybody but the people then existing, nor does it, either expressly or impliedly, assert any right, power, or disposition on their part to bind anybody but themselves. Because most Americans have lost any sense of our national history, we have to bring these issues forward to fill the void created by the Fabian school systems. When the framers of the Constitution, many of whom were Freemasons and had their own hidden agendas, as later episodes will reveal, spent 4 months from May 25th to September 17th, 1787, to create the U.S. Constitution. After the document was created in this convention, then the delegates had to sell the new document to the public before it could be ratified. The Federalist Papers is a collection of 85 essays written by Alexander Hamilton, John Jay, and James Madison promoting ratification of the new Constitution and supplied to the public through the newspapers of the time, and in all honesty, they were nothing but a marketing campaign to sell the Constitution to the states. The Anti-Federalist Papers were essays composed in opposition to a strong and centralized federal government as that proposed in the Constitution. It is primarily due to the protests of the Anti-Federalists that the first 10 amendments, known as the Bill of Rights, were added to the original Constitution. You have the Anti-Federalists to thank for the freedoms you enjoyed from federal intrusion since the Constitution was ratified, not those who envisioned the federal government and composed the original document. The only way the Federalists could get the Constitution ratified was through the concession of adding the Bill of Rights to the document to protect the freedoms of the people against federal intrusion. Contrary to modern perceptions, the Bill of Rights did not grant anyone any rights. The Bill of Rights was a leash on the new federal government, telling them which inherent and unalienable rights the new government could not intrude upon. You already have these rights, and the Bill of Rights was designed as a harness on the federal government to prevent the subversion of these inherent rights by the new federal government. Therefore, you have no constitutional rights if you think the document grants those rights to you. Now, ladies and gentlemen, if you doubt this assertion, then we only need to look at the Supreme Court case commonly known as Barron v. Baltimore, found at 32 U.S. 243 in your local law library. The facts of the case are as follows. Mr. Barron was a co-owner of a profitable wharf in the harbor of Baltimore. The city of Baltimore was expanding and doing a lot of construction, and as a result of this city construction, a lot of sand washed into Baltimore Harbor, creating sediment at the bottom of the harbor, which prevented Mr. Barron from landing his cargo-laden ships at the wharf because the buildup of sand and silt that resulted from the city's construction projects prevented the heavy ships from reaching his wharf without technically running aground. Mr. Barron sued the city of Baltimore as a violation of his Fifth Amendment rights of deprivation of property without due process of law. This case was heard before the U.S. Supreme Court in 1833, and it has never been overturned to this day. The court didn't even listen to the evidence brought by the city of Baltimore before rendering its unanimous decision that the Fifth Amendment did not apply to the states, but only as an exclusive check on the powers of the federal government. To fully understand this decision and how you have no constitutional rights, the exact verbiage of the decision rendered by the court itself should leave absolutely no doubt. Chief Justice Marshall rendered the opinion of the court, which states, in part, "The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. The people of the United States framed such a government for the United States as they supposed best adapted to their situation and best calculated to promote their interests. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily, applicable to the government created by the instrument. They are limitations of power granted in the instrument itself, not of distinct governments framed by different persons and for different purposes." Later in his decision, Justice Marshall states, "We are of opinion that the provision in the Fifth Amendment to the Constitution declaring that private property shall not be taken for public use without just compensation is intended solely as a limitation on the exercise of power by the government of the United States and is not applicable to the legislation of the states. We are therefore of opinion that there is no repugnancy between the several acts of the General Assembly of Maryland given in evidence by the defendants at the trial of this case in the court of that state and the Constitution of the United States. This court therefore has no jurisdiction of the cause, and it is dismissed." The High Court made a valid judgment by recognizing that the Fifth Amendment was a barrier for the federal government to not take property without due process of law. But to interpret the decision in more clear and understandable modern terminology for my viewers to understand, the decision could read something like this: "The people of the United States, the federal agent of the states, made their own constitution for themselves as each individual state created their own constitutions to either safeguard or not the rights of its citizens." You see, Mr. Barron, you are a citizen of the state of Maryland and not a citizen of the United States, so you have no claim under the Fifth Amendment for restitution for your property loss against the city of Baltimore, so take a hike. Now, this may sound a bit crass, but in essence, this is what the case ruling means. So let's translate this to today and see what it means. If Mr. Barron had no Fifth Amendment rights to claim as a U.S. citizen, considering that he was a citizen of the state of Maryland, what makes you think you have any constitutional rights today based on the U.S. Constitution? You claim to be a U.S. citizen, but are you really, given the Barron v. Baltimore decision? Justice Marshall dismissed Mr. Barron's case because the court lacked jurisdiction as a federal court over what was obviously a matter for the Maryland state courts. Based on this information, the only real citizens of the United States, as denoted by the Marshall opinion rendered by the Supreme Court, are those who live in the 10-mile square District of Columbia, created by the cession of land by Virginia and Maryland to form the boundaries of the capital and the U.S. territories like the U.S. Virgin Islands, Guam, and Puerto Rico. Any American that lives outside those specific boundaries and territories is not a United States citizen according to the strict letter of the law pursuant to the Barron v. Baltimore decision. As our upcoming videos will reveal, the term United States has a dual meaning, and the Barron v. Baltimore decision is only one of them. The other, more sinister meaning will be revealed in upcoming videos, and you're not going to be very happy to discover it once revealed. There is one major disconcerting admission in Justice Marshall's decision, and that is that the people of the United States created their government for themselves and their best interests. The question this raises is, who are these people of the United States that set up this government for themselves and their interests? The story we have been told about our history is that the states created the federal government as their agent to ensure that the best interests of all the states were secured both in commerce between themselves and commerce around the world. The federal agent was also there to help provide a navy to protect the interests of the states from foreign invasion and have the power to bring forth and enforce treaties, among other enumerated powers and restrictions. The Constitution and therefore the federal government only had authority once the states created the federal government as their agent. Under the law of agency, we find the premise for the creation of the federal government. The law of agency is an area of commercial law dealing with a set of contractual, quasi-contractual, and non-contractual fiduciary relationships that involve a person called the agent that is authorized to act on behalf of another, called the principal, to create legal relations with a third party. For all intents and purposes, the several states are the principals in an agreement to set up the federal government as an agent to perform certain specific functions on their behalf. As noted in the Declaration of Independence, it says, "We the people of the United States." If you examine the Declaration online, you will find that the word United is in lowercase letters and States is capitalized, yet in the Constitution, both letters are capitalized, signifying a subtle change in the relationship of stated United and the United States. This will be discussed more in depth in a later video, ladies and gentlemen, and it has greater significance than you can yet imagine. Under the law of agency, the agent can never supersede the principal, yet in the present United States, that is exactly what appears to have happened. The agent, called the federal government, now thinks it's the boss over the states and all their citizens, who were the principals in creating the original agent. The federal government has far exceeded its mandated authority and made every American believe that we are now citizens of the agent rather than citizens of our respective states, as decreed by the Supreme Court in the Barron decision. We report this to you now so you can ponder this information and more keenly see through the illusion you have been brainwashed into believing is reality. People want to challenge these things we are revealing because of their brainwashing with sanitized history at the hands of the Fabian Marxist machine. History books can be written to present any kind of propaganda they will, but the one place that the dark, ugly truth resides is in the laws of the nations. You can publish historical myths by controlling the publishing houses and the educational systems worldwide, by selectively omitting what you don't want the public to know, by selling your propaganda as history. But where the truth can't be hidden is in the law. This is why we're taking the responsibility to educate our countrymen through evidence found in the law. We have to do this because the truth has not been taught in our schools, only perceptual illusions and little more. To become a fully functional, cognitively advanced human being, you have to deal with the ugly truth, not continue to be controlled by illusions that have little basis in reality. To free your mind from the brainwashing and the illusion of reality you have been sold by mastermind controllers, you have to face these truths. To deny them only leaves your consciousness enslaved to the will of others whose only goal is to turn you into one of their cognitive robots. Ladies and gentlemen, we've just published a volume titled The Common Sense Revolution, Creating Common Ground and Genuine Common Sense. Endall, myself, and several others contributed to this work, and it's geared more towards those who may be new to many of the concepts that we've presented and talked about. Many people from different walks of life contributed their insights, observations, time, skills, and talents, and we're grateful to them for their assistance. Also, the fourth book in the second Cognition series is now available. It's called The Energetic War Against Humanity, the 6,000-year war against human cognitive advancement. I had the opportunity to read this manuscript before publication, and Endall did an amazing job with this piece of work. I'll place links to both in the description section for those who may be interested. Ladies and gentlemen, thank you very much for taking your time to listen to Attaining the Second Cognition. I greatly appreciate it. I extend my deepest gratitude and my heartfelt thanks to any and to all who take the time to open their mind, search for truth, and push forward in their own cognitive advancement and willful evolution. Once again, ladies and gentlemen, thank you. This is Doug Michael, and until next time, walk in peace.